Hello everyone, I am going to start the new topic with this caption. Why so much grief for me? No man will hurl me down to death against my fate. And fate, no one alive has ever escaped it. Neither brave man nor a coward. I tell you, it's born with us the day that we are born. Homer. An article published in the Tehelka in the current affairs section titled Mother, shall I put you to the sleep? And leisurely bath, the son was preparing for the mother, what is popularly known as Talekutal. Mother, having learnt about this, suddenly she escapes out of the home and ran away. Talekutal, it is a social custom or process of killing a elderly people, that is senicide. The close relatives of the family will kill a debilitated person who is unable to contribute to the family. This is an active form of euthanasia. So without the consent of the person who is debilitated, even if he wish to live also, this will be practiced, maybe because of the poverty. Yes, this talakutal is practiced as a social custom and it is widely accepted in that pocket, and nobody will come forward to complain against it to the law enforcing agency. I am Dr. Hanumanta Hamarappa. I am here to discuss the topic euthanasia. Eu means good, thanatos means death. This word is derived from the Greek, that is good death or mercy killing. The literal meaning is putting a person to a painless death, especially in case of incurable suffering or when the life has become purposeless as a result of mental or physical handicap. So, the question of putting someone to the death arises in three occasions. When the person is born newly, that is, when he is suffering from some of the incurable or congenital disorders, this question arises. Due to the aged process, old age, the organs start failing, and in that case also this question arises. Or in the when the person meets with some unforeseen accidents or that is mishap, in that cases also the person goes into vegetative state or brain death. That time also this question arises. So literally this question arises in three occasions. So in these conditions, so any amount of the medical treatment is nothing to offer to the patient. That is no good for the patient. Then in that case, the person can be put into the peaceful or dignified death. Then that is what is known as mercy killing or euthanasia. So these are the different types of euthanasia: voluntary, involuntary, non-voluntary, active euthanasia, and passive euthanasia. Voluntary means the person has expressed his will for mercy killing. Involuntary means the person has not expressed his will for mercy killing. In contrary, he has expressed in a contrary not to go for mercy killing. Non-voluntary means the person is not able to take any decision because he is in deep coma, and on behalf of him, his close and near relatives or doctor going to decide. Passive euthanasia is just acts of omission. The treatment is required, the treatment is not given. The life-sustaining measures are just removed. That it is acts of omissions. Active euthanasia is acts of commissions. Actively, something is made to the person to die. That injection is put, something like that. So, in physician-assisted dying or physician-assisted suicide, the idea or medicines are given to the patient, but he himself consumes it or he himself do the act of self-killing. That is what is known as pass or pad. Before the Hippocrates, the physicians used to think that the euthanasia is a part and parcel of their practice, and they used to kill the patients even without their consent, and they had no repentance for that. This was noticed by Hippocrates, and around 400 BC, he incorporated this into his oath, what is known as I will not give deadly medicine to anyone if asked, nor suggest any such counsel. In 1939, Hitler signed a decree of enabling doctors to grant mercy death in the beginning to the infants, and later it extended to old disabled persons, and later extended to many Jewish people against. The difference between suicide and euthanasia. Suicide, here the person self kills due to some psychological component or some attention seeking. In euthanasia, on the consent of the sufferer, the third party executes it. In the Lama and Dama, that is leaving against the medical advice or discharge against the medical advice, it is seen very routinely in the hospitals, in the routine practice. The patients will not be agreeing for some treatment or the number of the stay in the hospitals, and they go against the doctor's wish. Once they are out of the hospital, anything happened to them, they are responsible. Doctor is not responsible. Legally also, he is not bound. DNR is the overestimation of the CPR. It is seen prevailing in the Western world, and advanced directive is given by the patient to the near and dear ones. In case his respiratory or cardiac system is not functioning, he may not be resuscitated. That is DNR. The euthanasia law journey in India. This prevailing legal position on euthanasia has been established by a series of deliberation of three important cases, that is Gan Kaur versus State of Punjab in 1996, Aruna Shanbag versus Union of India in 2011, and finally Common Cause versus Union of India in 2018. In a landmark judgment on March 7, 2011, Supreme Court allowed passive euthanasia and also recommended the decriminalization of the attempt to suicide in Aruna Shanbag case. So, for the first time in India, the euthanasia, that is passive euthanasia, was allowed. Look at this interesting case, Aruna Shanbag. Her full name is Aruna Ramachandra Shanbag, was a nurse in a King Edward Memorial Hospital in Mumbai. In November 1973, she was assaulted by a ward boy by name Sohanlal Bharta Valmiki of the same hospital while changing her clothes in the hospital basement. Valmiki strangulated Shanbag with a dog chain around her neck. So, following this sexual attack, cut off oxygen supply from her brain, leaving her blind, deaf, paralyzed, and in a vegetative state for the next 42 years. From the day of the assault till the day she died on May 18, 2015, Aruna could only survive on mashed food. She could not move her hands or legs, could not talk or perform the basic functions of human being. So what happened to the Valmiki? In 1974, Valmiki was charged with attempted murder and for robbing Aruna's earrings, but not for the rape. The police did not take into account that she was sodomized. A trial court sentenced Valmiki 7 years imprisonment. This was reduced to 6 years because he had already served a year in the lockup. Then later Valmiki walked out of the jail in 1980 and still claims he did not rape Shanbag. Finally, on May 18, 2015, Shanbag, then 66, died of severe pneumonia. She was on ventilator support in KM's acute care unit. Yet another important landmark judgment, the Supreme Court of India legalized passive euthanasia in 2018. According to the judgment, an adult in his conscious mind is permitted to refuse medical treatment or voluntarily decide not to take medical treatment to embrace death in a natural way under certain conditions. It also laid down guidelines for living will made by a terminally ill patients who beforehand know about their chances of slipping into permanent vegetative state. The court especially stated that dignity in the process of dying is as much as part of the right to life under Article 21. To deprive an individual of dignity towards the end of life is to deprive the individual of meaningful existence. The court in the common cause issued guidelines regarding the advance directives, which are documents that detail the choices of the patient regarding treatment decisions, along with who would be competent to take decisions on their behalf in case of their inability to do so. While the guidelines were amended in February 2023 to facilitate easier implementation of the advance directives to a larger sections of the society, they still place an onerous burden on each applicant. Each advance directive is subject to the opinion of the two medical boards, and the decision of the boards can only be challenged via writ petition under Article 226. The current position puts the onus largely on the families of the patients, who are subjected to the rigorous bureaucratic process in order to give effect to the advance directives, which are notarized documents signed and testified in front of the judicial magistrate. Later, Supreme Court tweaked the previous judgment to do away with the necessity of a judicial magistrate to attest or countersign a living will. Supreme Court held that the attestation by notary or gazetted officer would be sufficient for a person to make a valid living will. Instead of the living will being in the custody of the district court concerned, Supreme Court said that the document will be part of the National Health Digital Record, which can be accessed by the hospitals and doctors from any part of the country. If the hospital's medical board denies permission to withdraw medical treatment, the family members of the patient can approach the relevant High Court, which forms a fresh board of a medical expert to enable the court to take a final call. Some of the changes that are brought to the 2018 judgment recently that look like promising. Earlier, for a living will, the judge has to countersign. That is, the district magistrate had to countersign. Now it is not required. Any gazetted officer or any notary can sign it. Regarding the accessibility of the living will, it will be kept under the national health record. It can be accessed by any hospital or any doctor from the India now. Earlier, it was kept under the custody of the district court. As regard to the constitution of the primary board of doctors, earlier the doctors, four doctors with 20 years of experience, the specialties including cardiology, neurology, nephrology, psychiatry, oncology was required. Now only three doctors, including a treating physician and two other doctors with 5 years experience in the specialty will be enough. The time taken to decide, earlier in the 2018 judgment there was no time limit. Now the primary or secondary board had to decide within 48 hours of on withdrawal of the further treatment. Regarding the secondary board, they had to approach to the court and court had to appoint the secondary board. Now hospital itself can appoint a secondary board. So what is the status of the euthanasia in the world? The Netherlands, Luxembourg, Belgium allows both euthanasia and assisted suicide for anyone who faces unbearable suffering that has no chance of improvement. Switzerland has euthanasia but allows assisted dying in the presence of doctors or physicians. Canada had announced that euthanasia and assisted dying would be allowed for mentally ill patients by March 2023. However, the decision has been widely criticized and the move be delayed. US has different laws in different states. Euthanasia is allowed in some states. How exactly this euthanasia can be executed? See, there are two ways. Whether the advance directive is present or not present. In case if the advance directive is present, that will be communicated to the treating doctor via the nominated representative or any close relatives, wife, brother, father or somebody, son. Then treating doctors, having learnt about this, if it is required euthanasia, then he will intimate to the hospital administration. The hospital administration constitutes a board, including three doctors. Part in that, one of the doctor will be part of the treating doctor. So totally three doctors who are having minimum of 5 years experience, and the doctor should be of the specialty concerned. Then this board, in presence of the relatives, examine the patient and they will give the report for or against. That will be communicated to the relatives. If it is for, then the same thing will be communicated to the hospital administration. The hospital administration again intimate to the DHO, district health officer. He will nominate one registered medical practitioner. Along with him, another two doctors will be appointed in the second board from the hospital. That again, specialty is concerned, and they should have, everybody should have minimum of 5 years experience. The second board, after examining the patient in presence of the relatives, also gives a report. That is medical board report 2. If the 1 and 2 are far for euthanasia, then that can be communicated to the JMFC, that is Judicial Magistrate First Class. Advance directive, the report of the board 1, the report of the board 2, everything should be sent to the JMFC. Then euthanasia can be executed. That life-sustaining measures can be taken out. This is the, in case of advance directive is present. If the advance directive is not present, then the treating doctor, if he thinks that the euthanasia is required, then same thing, he will intimate to the treating hospital administration, then they will constitute the board, and everything is like similarly. Only thing here is advance directive is not present. So this is how exactly this can be executed. In case the second medical board report is against the euthanasia, then the relatives can go to the High Court under section 226 article. Then the High Court will appoint a temporary bench consist of two judges. They in turn appoint a medical board. 4 doctors, 20 years of experience. Concerned specialties may be nephrology, neurology, cardiology, something like that. Then that board will come and examine the patient and they will give the report for or against. If it is for, it will be executed. If it is against, everything will be stopped there. Then that will be communicated. Same thing will be communicated to the JMFC. This is how the euthanasia can be affected. So thank you everyone. These are my references.